Hello, welcome back. Let's talk about Palsgraff versus Long Island Railroad, one of the great common law cases of all time, decided by Judge Cardozo, where Pearson v. Post was decided in the early 19th century, I believe 1808 if I'm not mistaken. The Palsgraff case was decided in 1928. And so it's a more recent case, almost 100 years old. But it's a great case. What happened here is, and what this case is about the notion of duty. What duties do we owe to other people when we don't have, let's say, a contract relationship with them or any fiduciary duties? We're not involved in a common venture. We're not co-owners of a business. What duties do we owe to strangers? And a large amount of tort law is about answering that question. And Palsgraff is a really important case because it really asks us to push our intuitions about what duties do we owe to others. The facts of the case are relatively straightforward. They're legendary. Mrs. Palsgraff, known to her friends as Helen or Lena, Helen Palsgraff is at a train station with her two daughters. They're going to go take the train to Rockaway Beach. It's a hot summer day. Train pulls in, it's about to pull out, to a different location. A couple of guys are about to board the train, and the conductors push these guys into the train. They're holding a package. The package falls out, and all the commotion, causing an explosion. Apparently there's some fireworks. By some reports, those were actually small bombs in that package. But whatever the case is that when the fireworks or small bombs exploded, there was a commotion on the platform of the train station, and that commotion led to this very heavy scale, like you see at Publix, where you go and get your weight taken. It fell on and injured Mrs. Palsgraff. And so she sues, trying to recover. She sues the Long Island Railroad, saying that, you owed me a duty and you did not, protect me from injury. What makes this case so famous is that Judge Cardozo, who decides the case for the majority, there's going to be a dissent, but he says, look, you don't owe a duty to everyone. You don't owe a duty to the whole world, You only owe a duty to individuals who are, in his famous phrase, in the zone of danger. In the zone of danger. And the thing about it, the way Cardozo looks at the case, he imagines Mrs. Palsgraff standing all the way on the other end of the platform from where the fireworks fell. And so, that duty wasn't owed to her. He also talks about causation, because one of the ironies of this case is that it's completely wrongly decided. Long Island Railroad is it's in the transportation business, and it's what common law considers a common carrier, and common carrier owes its passengers the highest duty of care. And so Mrs. Palsgraff, assuming she had already purchased her ticket, right, and she is on the train platform, you could argue that the railroad owes her this high duty of care as she's waiting for her train. But Judge Cardozo has another argument up his sleeve, the argument of causation. Even if we're going to say that there is a duty owed to everyone, or you buy my argument that as a potential passenger of the train, with or without a ticket, she's owed a high duty of care. Cardozo goes on to say that, the falling of the fireworks, from the two passengers who were trying to board that train at the last minute, really, there's a remote connection between the falling of the fireworks and the falling of the scale, In between, there's too many things, intervening events are taking place, basically rupturing the causation and, putting an end to the duty here that the railroad may have owed, assuming it did owe a duty to Mrs. Palsgraff. That's why this case is really important, because it asks and invites us to take a closer look at, what duties do we owe to each other. And even when we owe duties to other individuals that may be in the zone of danger, that may have a contractual relationship with us, how far does that duty go? How deep does that duty go? What about superseding or intervening events? And so a lot of time, for example, in law school, in tort law, is spent exploring all of these subsidiary questions. For now, though, I just want you to know the main elements of negligence, right? The main elements of proving a case, proving that somebody, injured you, because they breached their duty of care that they owe to you. And the main elements are duty, right? Everyone owes a duty to other individuals to act in a careful manner. The second element is breach of the duty, which is sort of negligence with a small n. That is to say, when you're not careful, when you don't act with reasonable care, when you don't take reasonable precautions to avoid injuries to other people, you are said to have breached your duty of care. The next element, however, is causation. And causation is this very, like I say, very complicated area of tort law. And there's different types of causation. But the basic idea is that there be a connection between the breach of the duty of care and the actual injury that occurs to the victim, to the injured party. One way of looking at it is, was the injury foreseeable when the person did not act in a reasonable fashion? And finally, there does have to be damages, or the damages have to be quantified in some kind of economic or dollar fashion. So these are, in generally speaking, the elements of a negligence claim. And Palsgraff is a great case because it asks an unjust outcome, if you ask me, but it's a great case nevertheless because it invites us to ask about what duties do we owe other people. We'll take a look at one more case, a contract law case, in the next and last video.